Hi, welcome to our webcast of February 26, 2016. Hello and welcome. My name is Christian Debray and this is Amy Asbrook, the director of Toujours Vivant, Not Dead Yet. Toujours Vivant, Not Dead Yet is a non-religious organization by and for people with disability and are alive. Our goal is to inform, unify, and give voice to the disability right opposition, to assisted suicide, euthanasia, and other ending of life practices that discriminate against people with disabilities. Today's topics. The Special Joint Committee make its recommendations. This is quite long. The Liberal back off from party line on assisted suicide, and the last one, contact your MPs. So I give the voice to Amy Asbrook.
Okay, thanks. So the report and recommendations of the Special Joint Parliamentary Committee on Physician Aid and Dying were published yesterday, and they were as bad as we expected. The recommendations do nothing to protect vulnerable persons and prevent suicides while opening the door wide to euthanasia and assisted suicide of old, ill, and disabled people. And just to keep in mind that if you look back at the original Carter case, what the plaintiffs suggested, this is way much further than that. What the plaintiffs suggested were things like a mandatory psychiatric evaluation, that the person would have a consultation with a palliative care doctor, that the person would have to, take treatments that were not too invasive, that there would be an approval panel that would approve assisted suicides, and this has gone way beyond that. So,
Way
looser.
Far away.
What the recommendations do. Recommendation number 1, the terms relating to medical assistance in dying, meaning grievous and irremediable medical condition that causes enduring suffering that is intolerable to the individual in the circumstances of his or her condition, those terms, do not require further statutory definition. Now, those are very central to the law, and you would think that they would need some definition because most of them are very subjective terms, and you would want to have some objective definitions.
And all we know that what some lawyers could do with a comma misplaced somewhere, and they could play over it and do very nasty things.
Right, exactly. So they're finding that it doesn't need any more clarification seems a little strange to us.
Yeah.
Recommendation 2, that medical assistance in dying be available to individuals with terminal and non-terminal conditions. Well, that was in the final Carter decision, the one that came from the Supreme Court, so we're not really surprised by that. But to have it stated as, we'd hope that this set of recommendations would be a little better than the Supreme Court decision, and here we are disappointed.
Yeah, it goes down and down at every recommendation.
Right, exactly. Recommendation 3, that individuals not be excluded from eligibility for medical assistance in dying based on the fact that they have a psychiatric condition. This is another thing that is directly opposite of what the plaintiffs in the Carter case suggested. They said that any person who has major depressive disorder should be excluded. And this says, no, people with psychiatric disorder should not be excluded.
Yeah, everybody. And everybody knows that people who are suffering from schizophrenia could harm themselves very badly, including to the death.
Right.
And they are sick. They should be treated.
Right. And also people with depression need help, don't need to be killed.
Same thing.
Right. And a lot of times people with depression feel like the mental health industry abandons them because they can't, get fixed with a couple of pills. So, that's one of the reasons people end up feeling suicidal. They feel abandoned.
Yeah.
Recommendation 4, that physical or psychological suffering should be recognized as a criterion for access to medical assistance in dying. So if you have a physical suffering or if you have a psychological suffering, so not just are they going to include psychological suffering, but that could be the only basis for having medical assistance in dying.
Young adult, 18, 19 years old, losing his further girlfriend will say, "Oh, I want to die," and it may be sufficient.
Right, exactly. Right. If the person can show that they have enduring suffering.
Its suffering is grave and it's permanent.
Right, exactly.
So.
Right. Recommendation number 5, that the capacity of the person requesting medical assistance in dying is to provide informed consent should be assessed using existing medical practices. And that's sort of, we had asked for that there be a special way to assess the capacity that was more based on a suicide prevention model rather than just a regular informed consent model. But this section goes on to say that the process should emphasize the need to pay particular attention to vulnerabilities in end-of-life circumstances. Well, first of all, since it's not just end-of-life circumstances, because we already talked about how it's not just people with terminal illness, that's a little strange. But in the Carter decision, they said that they want an exception for people who are vulnerable to inducement to commit suicide. But this specific exception has been downgraded and stuck into the general competency determination. And so it doesn't have any, it really ends up being meaningless.
Completely ridiculous.
Right, because they're not looking at psychosocial factors. They're just looking at capacity, which is not, it's not broad enough to include the factors that make people vulnerable.
Basically, if you are able to name the Prime Minister of Canada and your address, you're competent.
Right, exactly. Recommendation 6, that the Government of Canada implement the law in 2 stages, with the first stage applying immediately to competent adult persons 18 years or older, to be followed by a second stage applying to competent mature minors coming into force no later than 3 years after the first stage has come into force. So that means people, it says competent minors, so that means adolescents who could prove they're competent and mature would be able to have access to assisted suicide, even though those same minors would not be able to get married, would not be able to have sex. Those would be against the law, but they would be able to kill themselves.
Yeah, but we send them to the war at 18 years old, so we could kill them. That feels normal.
18 years, we're talking about people younger than 18.
Oh, but you never heard about children soldier?
Right, but that's illegal here.
Oh.
It's illegal to have child soldiers here.
They should not know that when they write that.
Right, they must have forgotten.
Yeah, they forgot.
So, they're talking about people's rights, but, there are already ways in which we restrict people's rights for their own good, and such as marriage and sexual consent and that sort of thing. For some reason, they decided not to apply that to adolescents, and especially adolescents because of their development are especially vulnerable to suicidal feelings and behaviors, and would be very vulnerable to wanting to commit suicide if something bad happened.
Yeah.
Okay, recommendation 7. That permission to use advanced requests for medical assistance in dying be allowed any time after a person is diagnosed with a grievous and irremediable condition, but before the suffering becomes intolerable.
Could be very dangerous.
Right, so that means that since Christian already has a grievous and irremediable condition, he could sign up for advanced directive assisted suicide.
But in 3 years, I will change my mind.
Right.
But try to remove it.
Right, exactly.
Anybody who have tried to change an information over a government thing will know what we talk about.
Right. People have terrible difficulty removing do not resuscitate orders from their charts, even if they didn't even put them there in the first place.
Yeah.
So that's why we're concerned that it would.
And very simple thing like a mistaken information over the healthcare system card, you will have a lot of trouble to change it, even if you could prove it. My eyes are blue, not brown. You show it, but it's not enough.
Yeah, yeah. So, recommendation 8, that medical assistance in dying be available only to insured persons eligible for publicly funded healthcare services in Canada. And that means in the provinces, most provinces, you have to be in the province for 3 months in order to be eligible for health insurance. So
at first sight, it seems to be nice.
But, well, a lot of people could come and stay in Canada for 3 months, say they're trying to immigrate and stay in Canada for 3 months and get a health card and then have assisted suicide.
So it's a try, but it's not enough.
Right. It looks like they're trying to discourage suicide tourism, but it's not going to be very effective. It's easy to get around.
Yeah.
Recommendation 9 is, where possible, a request for medical assistance in dying is made in writing and is witnessed by 2 people who have no conflict of interest.
When's possible.
Right. So that means when it's not possible, that's not a problem. So it might not be possible to have a written document. Oh, well, too bad. It might not be possible to have a document with 2 disinterested witnesses.
So,
oh, well, too bad.
Even those 2 people, they just have to say, oh, I'm not interested, and nobody will
right. I don't
do
have any
anything about
conflict of
it.
interest.
Yeah.
And there's no way to go back and prove that.
And you will see a little bit further, even if you find that somebody is interested, you will not be able to do anything against it.
Right. Recommendation 10. When the freedom of conscience of healthcare practitioners be respected, while at the same time respecting the needs of a patient who seeks medical assistance in dying. At a minimum, the objecting practitioner must provide an effective referral for the patient. So the doctor can say, I'm not going to do assisted suicide on you, but he or she has to provide you a referral.
You will not be the shooter. You will be just to be coming with
the contractor.
No, quand on est
the agent.
You know, you follow and you aid the criminal.
Oh, the abettor. You aid and abet the criminal.
Yeah. Anyway, you are forced to be part of this thing, even if you are not agreeing.
Right, exactly. So basically, the person you don't want to do it, so you have to find somebody to do the work. It's like hiring a contract killer because you don't want to do it yourself.
Yeah.
And you have to do that according to this law, or according to these recommendations. These aren't the law yet. These are just recommendations. Recommendation 11, that all publicly funded healthcare institutions provide medical assistance in dying. That
What
means
happened with
hospices,
palliative
palliative
care?
care. Yep. That means hospices can't be exempt. That means palliative care centers can't be exempt. Palliative care centers in hospitals.
But this is not their mission.
Right. Palliative care, assisted suicide runs counter to their mission, their philosophy. So how can they be forced to do this when it's counter to their mission?
I don't know. That's a bad idea, sounds to me.
Right, exactly. Recommendation 12, that a request for medical assistance in dying can be carried out only if two physicians who are independent of one another have determined that the person meets the eligibility criteria for medical assistance in dying. So those two doctors have to decide that the person is eligible, and they have to be independent of each other, but that's not
Yeah, but
defined.
it doesn't have to know the patient. They
Right.
just to be independent.
Right. Neither of them has to be the treating physician. It doesn't say anything about it. So it's easy for people to go doctor shopping.
Yeah.
If the first doctor says, no, I'm not going to do it.
Wide open door to doctor shopping.
Right. You can just go to the guy next door and say, will you do it? So, and in fact, if the one guy says, I don't want to do it, you could say, well, you need to give me a referral.
Yeah.
If
So,
you're not doing it for a reason of conscience, you have to give me a referral.
so the doctor shopping will be very easy. You have to see a first doctor, and the next one will do the thing.
Right. The physicians, nurse practitioners, registered nurses, and registered nurses working under the direction of the physician may provide medical assistance in dying. So go ahead.
Oh, they will be forced to do it. The doctor at least have the right to refuse to do it, but those people doesn't have the right to refuse it.
Well,
They
it doesn't
have to
say
do
they
it.
do.
They have to.
It doesn't say they can't. It doesn't say they can refuse it. So if a nurse is working under a doctor's direction, she has to do it or he has to do it.
Yeah. This guy, midnight tonight, kill him.
Yeah. Yeah.
And it's legal.
Recommendation 14th, that any period of reflection, if there is one, for medical assistance in dying is flexible and based in part on the rapidity of progression and nature of the patient's medical condition as determined by the patient's attending physician. So now we have an attending physician who's making a determination about the person's diagnosis. But it's not even clear if there's going to be a waiting period. And if there is, it has to be flexible.
And it's the decision is only the doctor. The doctor could just do his inspection in the hospital and ask to the patient, do you want to die? Yes, 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 I want to die. Okay, I give you 2 hours. I will do my round on the hospital and I'll be back, and that's it. He had give a period of reflection long enough to fulfill his standard.
Right. Recommendation number 15, that the process to regulate medical assistance in dying does not include a peer review and approval process. This is very bad. It's not just that they're not suggesting that they have a peer review process or a judicial process. They're saying it can't be included. And that's bad.
No comment.
No comment, right. That Health Canada lead a cooperative process with the provinces and territories, creating and analyzing national reports on medical assistance in dying cases, compiled on an annual basis and tabled in Parliament. So The national government is going to gather information from all the provincial governments.
But which information?
Right, exactly. You don't know what kind of information they're getting from the individual government.
So it could be only the minimum. We had killed 10 people this year, or 120, I don't know. It could be very, very, very small, or it could be detailed.
Or it could be information that doesn't match the other one.
Yeah, and it's depending of the government of each provinces, and it could change even in the each provinces without any indication.
Right. But they're going to have to gather that and report on it at the end of the year. That a statutory review of the federal legislation be conducted by the appropriate committees of the House and Senate every 4 years. So once they have these data, they're supposed to analyze them and decide how the program is going, and they need to do that
If there
every
is
4
something
years.
to analyze.
Right. I mean, there will be something. It may be extremely disorganized, but there will be something.
Yeah. At least they will have something to study. It's a kind of minimum of minimum of minimum.
Right. Recommendation 18, that culturally and spiritually appropriate end-of-life care services, including palliative care, be available to Indigenous patients. That's great that they're actually going to try to do that.
For Indigenous people.
Right, for Indigenous people.
So at least they have something, but it's kind of, okay, we think of you, don't do anything more.
Right. That's the only population they're talking about having access, care for Indigenous people.
Yeah.
If you look at the next item, excuse me, I'm sort of lacking water here. No, recommendation 19th, the Health Canada re-establish a Secretariat of Palliative and End-of-Life Care to develop a flexible integrated model of palliative care by implementing a pan-Canadian palliative care and end-of-life strategy with dedicated funding. That doesn't say people are going to get palliative care.
Yeah.
It says they're going to build a bureaucracy.
Yeah. If you have palliative care, you may do that. If you have palliative care, you may do that. But nobody said you must have palliative care.
Right. There's nothing here that says that people who need it are going to get it. It says that they're going to build a bureaucracy.
Too bad.
With funding. But what that bureaucracy will do is anybody's guess. It could just talk about palliative care. Who knows? That the Government of Canada, this is recommendation 20, that the Government of Canada support the Pan-Canadian mental health strategy, changing directions, changing lives, and ensure that appropriate mental health supports and services are in place for individuals requesting medical assistance in dying. So it's great that they're going to help support the mental health program, but again, it's ensuring that mental health services are in place for people who are asking for medical assistance in dying.
And have access before you die.
Right. What about people who need mental health care but who aren't to the point of asking to die yet? Those are the people who need to be treated so they don't get to the point of asking to die.
But afterward, when they die, maybe somebody would look at it.
No, maybe not.
Maybe not.
Yeah. And the final recommendation, number 21, that Health Canada and the Public Health Agency of Canada work with the provinces, territories, and civil society organizations to develop a pan-Canadian strategy to improve the quality of care and services for individuals living with dementia, as well as their families. Which is great, except for that's a small segment of people who are concerned with this. But it's not all of the people who are concerned with this, because as we know, a lot of people with disabilities, the main reason people ask for assisted suicide are all related to disability, and this set of recommendations does not address those. Here are some other notes on the recommendation. The person is not required to accept treatment for their suffering. And
Even the minimum.
right, even the minimum treatment. And that was something that even the plaintiffs in the Carter case said would be okay. Eligibility is determined by agreement of two doctors. The report is silent on what happens if the doctors disagree.
And you have to realize that the second opinion is just an opinion. So even if you disagree, the first one could say, okay, I don't accept your opinion, and I will kill the people.
I've heard your opinion, but I don't accept it.
And I kill the guy.
Right. The doctor has to assess the competence, physical and mental factors that interfere with decision-making, the informed and voluntary nature of the decision, and whether the person is vulnerable to inducement to commit suicide. Now, doctors are not psychologists, they're not social workers, they are not community outreach workers. They don't go
and they are very poor in average to treat pain.
Right. And so they don't go into people's houses to decide if grandma's being abused, or if she's being coerced, or if she's being made to feel like she's a burden on the family, and why doesn't grandma just pass away so we can get grandma's
so far for the informed and clear decision.
Right, exactly. That's why we had talked about having a psychosocial evaluation to clear all that up. Either assisted suicide or euthanasia is allowed, but no information about how the death will be caused is included in the recommendations. So they don't talk about whether there will be, if it's assisted suicide, whether the person has to take pills, whether somebody has to be there while the person dies.
And so they will give the training after it will be gone, not before.
Right.
Something fishy about it.
Right, exactly. What the recommendations don't do. There is no requirement that the person be able to commit suicide without help. Be unable to commit suicide without help. And that was part of the Carter decision.
That was the true question. And the target was to prolong the life of the people who may need assisted suicide. But right now, that's not the case anymore. They want to shorten the life of people who may suffer even a little bit.
Right, exactly. So in the Carter decision, they said that people are being deprived of their charter right to life because they might have to commit suicide earlier than they would if they had assisted suicide. But they didn't require that the person be unable to commit suicide. So that was not in the recommendations.
So instead of prolonging the life, they shorten it.
Right. There are no provisions for accessibility to ensure effective communication in the application process. No scribes, interpreters, print materials in alternate formats, or communication technology.
So I don't understand, because even people who are for the assisted suicide should ask it, because it's a need for those people either.
Right, but the thing is that if it's easier to just run over the opinion of somebody who can't speak if you don't try to help him speak.
We are not interested by your opinion. You're too old, you're sick, or you're too sick, or whatever, we will kill you.
Or if they say, well, we just don't have the technology to help you speak, or we don't have any way at this hospital to help you speak.
So in some doubt, we will kill you.
Right. Or we don't have an interpreter so you can participate in this conversation about what's going to happen to you.
So,
There is no separate psychosocial evaluation required to determine whether the person is vulnerable to inducement to commit suicide. We already talked about that
Yeah.
before. There is no obligation that palliative care be provided or even available to the person. No provision is made for home access modifications or home-based personal assistance services to enable the person to age in place and avoid institutionalization or from overburdening family carers.
so your choice, if you don't have access to that, your choice is between suffering and death, not another choice, a third or fourth choice that who could be palliative care and home care and things like that. No, no, no. You're suffering or you'll die.
Right.
Choose.
Right. They don't provide any way for people to do other than go into institutions or stay home and overburden their families. There's no support to prevent that.
Again, so far for the informed and clear choice.
Right. Oops. Let's see. There is no oversight body recommended, nor inclusion, nor indication of what information will be gathered for annual statistical reports.
We have already talked a little bit about it, but the answer is still the same. It's depending of the government in place and the people who administrate it. So it could be good or could be very bad, but at least it will be completely different from one province to the another.
There is no mandate for peer counseling to deal with disability adjustment issues. So if somebody becomes disabled and they need to talk to somebody who's been through that,
it's denied to you.
well, it's just not available. Nobody talks about it. And it's hard to find other people who have the same disability, especially if you can't get around because the transportation is inaccessible.
Yep.
There's no requirement of a pre-existing relationship with the treating physician. We already said that. That goes to doctor shopping. Administrative or judicial review of the eligibility determination is forbidden. We already said that. There is no mechanism to enforce the requirement that physicians report assisted suicides or euthanasias that they perform, especially where A, assisted suicide rather than euthanasia is the method of choice, and B, the act is performed by a nurse or a physician assistant.
So they could report it, not report it, report a part of it, whatever. There's no requirement, and there's no, nothing could happen to them. They do whatever they want about this fact.
Right, and we know that happens already in Belgium
yeah.
and other places. So,
But even in the law, they force them to report, but there's no consequences if they don't do it.
right.
And in this recommendation, they say they should not even have the obligation of.
Right. Well, they don't even say anything about it. So
do whatever you want.
Right.
There's no trouble. You will not be sued.
Right.
Nothing will happen. You could kill how many people you want to kill.
Okay. The Liberals back off from the party line on assisted suicide. That's our next item.
Yeah. The last week we said that they will be forced to follow the party line.
Right.
But this week we say they changed their mind, but it's not sure. So we will see next week what will be the next reaction. I don't know.
Right, exactly. Contrary to what we told you last week, the Liberals have backed off on their pledge to force a party line vote on assisted suicide bill, at least for the moment. There is no word on what they plan to do next week. So stay tuned. Contact your MPs. This is probably the most important part of the whole
Yes.
webcast.
You have questions to ask, that's the time to do that to your MP.
Questions to ask and things to point out to them about the recommendations. So we've talked about the recommendations. We've talked about things that should go in the recommendation. This is where each person has to step up and take their responsibility for the government. Now that we know what's in the recommendations that have been given to the House of Commons, it's time to contact our MPs to let them know what protections to add to the assisted suicide bill. We've talked about some important safeguards in the past, including 1, a psychosocial assessment for competence and vulnerability. 2, having a judge or administrative panel decide eligibility for assisted suicide. 3, access to palliative care and home-based services to ensure independence and autonomy. 4, ensuring that hospices are euthanasia-free zones. And those are just some of them. Those aren't all of the ones we've talked about, but those are a few of them. Now is the moment to contact your MP. Visit the Parliament's website at http://parl.gc.ca for phone numbers and email information, or send a free letter to your MP.
You don't need a post stamp at all.
Don't need a postage
When you write to your MPs, there's no need. There is an address to respect to fulfill this requirement.
Right. So write to your MPs at the top of the envelope, write the name of the member of Parliament that you're writing it to, and then House of Commons, Ottawa, Ontario, Canada, and then the postal code is K1A0A6. So that's K1A0A6. That's the postal code for Parliament, and you don't need a stamp to send that letter. Okay, to view our, excuse me, I'm sorry, I got lost here for a second. To view our webcasts, find them on YouTube or the search engine of your choice and input the terms euthanasia and disability, and you'll find all our
it's very easy.
Webcasts in the past. To participate live, send me your email address and I will send you a link to join us live, and that will arrive about 15 minutes before we start.
You're welcome.
Right. For more information on the subjects we discuss, visit us on Facebook at facebook.com/toujours vivant, not dead yet, at our website at tvndy.ca. You can send us an email at info@tv-ndy.ca, or you can follow us on Twitter at @TVNDY. Thanks for being with us, and please join us again next week. Thank you, Christine, for helping out.
Thank you, everybody, and take care of you.
Have a good week.
See you next week.
Goodbye.
Bye.